Today is September 29th, 2021. A week from today, next Sunday, is September 5th, 2021, when we shall meet again as we have met every September 5th since that numbing Tuesday night 4 years ago when Gauri Lankesh, our dearest friend, comrade in arms, sister, daughter, and aunt, was shot dead in cold blood as she returned home from work late, not so late that night. The killers and the fanatical organization that killed her had been stalking her and had also most likely killed Narendra Dabolkar 2013, Govind Pansare 2015, Kalburgi 2015. They tried to snuff out a brave, clear, laughing, rational voice that night. Little did they realize that in her death and killing, she scattered her sense of being and living across the land, over the seas and oceans, voices encore, resonating with anger, tears, defiance, and resolve at this bloody loss, the snatching away of our Gauri. Only a day ago, we got the news that the city of Burnaby in Canada has declared September 5th Gauri Lankesh Day. Canadians of Indian origin had much to do to make that happen. The mural dedication to Gauri Lankesh speaks of her commitment to scientific temper and against religious fanaticism. Apart from the small, tightly knit band of close associates and family who form the Gauri Memorial Trust, and that fiery band of human rights foot soldiers who constitute a vast and growing band of human rights defenders at Citizens for Justice and Peace, we have precious participation today, as always, from Indira Amma, mother of Gauri, and Kavita Lankesh, a sensitive and acclaimed filmmaker in her own right, who has, with tears of dignity and courage, been at the vanguard, not just of the movement to ensure that Gauri Lankesh and Parvati Lankesh's values resonate among our people, but has been doggedly pursuing legal remedy and that elusive word, justice, for Gauri. At the trial, ongoing for 4 years now, and at the Supreme Court, when the accused exploit loopholes to escape the long and wide arm of the law, it has been my personal privilege and that of CJP to be a close ally in this fortitude-filled endeavor. To the advocates and counsel, senior counsel who have given of their time and commitment, we are so very grateful. Who are the Gauri Memorial Trust? The founding president, until recently, was the veteran freedom fighter, 103-year-old H.S. Doreswamy, who ran the publication house Sahitya Mandira and the Indian nationalist newspaper Pauravani during colonial rule. Active during the freedom struggle, he continued his rigorous activism right until his passing and was known as the conscience keeper of Karnataka. Apart from myself, there is Deepu, filmmaker who runs Pedestrian Pictures, an alternative media house and a social activist. There's Ganesh Devi, well-known linguist, cultural critique and activist. We are privileged to have as patron Siddharth Vardarajan, editor and founder of The Wire and a noted journalist. Chukki Nanjudaswamy, convener Rajya Raita Sangha, a premier farmers organization in Karnataka, founded by her father, late Professor Nanjundaswamy. K. Neela, social activist and writer from Kalburgi. Dinesh Amin Mattu, senior journalist and writer. K.L. Ashok, convener, Karnataka Communal Harmony Forum and social activist. Rehmat Tarikere, professor of Kannada University and a noted writer and cultural critique. A.S. Prabhakar, professor of Kannada University, specialist in Adivasi culture and communities. Abdul Salam Puttige, editor of Artha Bharti, a popular daily in coastal Karnataka. D. Narasimha Murthy, social activist and convener, Swaraj Abhiyan, Karnataka chapter. Muniswamy, senior Dalit activist, president, Federation of Dalit Organizations in Karnataka. Noor Sridhar, social and political activist, convener Karnataka Janashakti, and none less than Professor V.S. Sridhara, professor of English and human rights activist. And now to today, a very special lecture in ongoing salute and tribute to our Gauri. Gautam Bhatia, young erudite, a practicing lawyer and academic with close involvement in constitutional rights litigation, be it the privacy stroke Aadhaar case this legal challenge to Section 377 and decriminalization of homosexuality, and so many others. Author of Offend, Shock or Disturb, Freedom of Speech under the Indian Constitution 2016, and Transformative Constitution, a Radical Biography in 9 Acts 2019. He is also a science fiction writer. The subject and focus of today's lecture could not be more timely. Dissent is not treason, understanding national security laws. We really look forward to the event, the lecture, and the question and answer session after the lecture. Given the recent painful, shocking developments, especially the use of such national security laws, UAPA, NAC, state preventive detention laws, to incarcerate on false charges thousands of activists, academics, lawyers, and dissenters, the subject for us was the logical choice. To have a young and well-acclaimed lawyer and scholar, a deep thinker as it were, to deliver it is a real privilege. This lecture is also being streamed on CJP social media handles, including our Facebook. We are deeply grateful to Live Law for also live streaming it on their YouTube channel. Professor V. Sridhar will formally chair the session. After the question and answer following the lecture, we do look forward to his concluding remarks. Before I hand over to Professor Sridhara, I would just like to pay formal tribute and express our collective outrage at the lathi charge on protesting farmers yesterday by the Haryana police on the orders of a district magistrate. We also know that UAPA and other draconian provisions have also been put against the peacefully protesting farmers. We also know that Isha Lankesh, Gauri's lovely niece, may not be able to be with us because she's at a hostel, but will catch the lecture later on Facebook or YouTube. Gautam, we welcome you with all our hearts and with a lot of love. Thank you so much for being here.
Thank you, Tista, for the nice introduction, and also pointing out what happened yesterday is very relevant for our concern, because in fact, this series began with a talk by Justice Nagmohan Das, retired High Court Justice of Karnataka, on the Constitution of India. This is the third in the series, but second on the same topic of Constitution. Today, we all know that for us, for fighting for justice and human rights, Constitution of India seems to be the biggest hope, that even when it is completely battered, its clauses are violated, we can still rally around the basic tenets of Constitution. So we really look forward to Gautam Bhatia's presentation on that. And I'm sure that we will get more insights into the functioning of democracy in India and the role of Constitution in that. So without much ado, I will request Gautam Bhatia to make his presentation. It will perhaps go for about 40 to 45 minutes. Then I request all the participants to post your questions on the chat box, so that makes it easier and simpler to avoid repetition. But we'll see to it that most of the questions asked will be responded to. So with this, over to Gautam Bhatia.
Thank you so much both for the very kind introduction and for inviting me to speak. It's a great honor to speak at the Gauri Memorial Lecture. And I think that if there was one thing that really characterized the work of Gauri Lankesh, it was a skepticism towards all kinds of power and authority, and the insistence on a ruthless questioning of all that's there. And it's in that spirit that I want to frame my remarks today. Maybe a little more skeptical about not just what's happening, but also about the proposed solutions, and perhaps a little bit of skepticism about the way in which we speak about the Constitution these days as well. I want to begin by setting out two quotes. The first quote goes as follows. It says that the court's judgments were wrong because their experience was limited to dealing with the crime after it has been committed. That's the first quote. The second quote is as follows. the power of preventive detention is precautionary power exercised reasonably in anticipation and may or may not relate to an offense. The anticipated behavior of a person based on his past conduct in the light of surrounding circumstances may provide sufficient ground for detention. The first quote is by Donald MacLeod, former Lieutenant Governor of colonial India, speaking of various provisions in the 1871 Criminal Tribes Act that had been struck down by the colonial courts. Donald MacLeod did not like that because he thought that the colonial courts were taking too generous a view and too liberal a view of notions of rights. And because the Criminal Tribes Act had various provisions for extensive surveillance of people, even without any indication of any crime having been committed, they deserved to, be held invalid. And Donald MacLeod said that you need to understand that it's not always, sometimes you have to put people behind bars even before crimes are committed. The second quote is by the Supreme Court of India after independence under the Constitution in a case called Sukhpal Singh. And I wanted just to think about the similarities, and not just the similarities, but the differences, because the first quote is by a colonial executive official who is criticizing colonial courts set up by the British, because they don't seem to understand that you should be able to put people in jail before crimes have been committed. And the second is a quote by a court saying that, well, yes, the whole point is to put people in jail before crime has been committed. And in between these two quotes, you have many decades and you have a constitution. And still, the similarity is very striking. And I think that it's worth thinking about, in a little more detail. So moving on, leading from that, I think there are basically there have been three lines of thought when it comes to the record of civil rights in independent India in the context of the Constitution and the courts. The first line of thought has been that, well, after independence, there was a period of around 2 decades when the courts were still, they had a colonial hangover. They were still finding their feet. The abyss was reached with the judgment in the habeas corpus case, ADM Jabalpur versus Shivkan Shukla. After that, there was a course correction, and then now things have improved after in the PIL era. So that's the first line of thought, and of course there are a few aberrations. So the second line of thought is that there has not been one breaking point or one point at which there was this big change in the Supreme Court's behavior, but over time, since independence, there has been a more consistent trend of judicial deference towards national security laws, towards laws that establish a state of exception, that depart from normal criminal law principles, that depart from basic protections of rights in criminal law statutes. And that has been a consistent trend. But the reason for that is that our judges have consistently failed to correctly interpret and understand the Constitution. They have chosen to interpret the Constitution in a way that accords with what the executive wants, with, again, a few exceptions, with a few courageous exceptions. But the Constitution is great. The Constitution is good. It's progressive Constitution. It's transformative. And the problem has been bad judges. So it's a problem of bad judges and a good Constitution. And if we're just able to, make really good arguments about how to interpret the Constitution, if we're able to have the right judges in place, over time, there will be more progress towards, a civil rights protection, and there will be more resistance against national security laws, sacrificing civil rights at the altar of a broader public interest. That's the second line of thought. And I think that I think the first line of thought is definitely wrong. And I think it's almost at this point intellectually dishonest to continue holding on to that, because there comes a point at which the aberrations grow so numerous and so voluminous that they're no longer aberrations, right? So, it's hard to forget that just 2 days ago, we were at the third anniversary of the arrest of 4 of the individuals involved in the Bhima Koregaon case involving Sudha Bharadwaj and others. Their bail has been denied at every level of the judiciary, at every court on multiple occasions. And I think that when you have cases like that piling up, you really can't say that these are aberrations anymore. And so I think the first account has been thoroughly discredited. The second account is somewhat more persuasive, but I think that it suffers from a number of problems as well. And I think that an honest reckoning with the problem that we face needs to take into account the role of the Constitution in enabling a number of issues that are there before us today. So I don't think it's as simple a case of a good Constitution and bad judges. I think that there are various design features and structural issues in the Constitution that make bad judges able to do what they're doing. And I wouldn't even say bad judges. I think judges of any color. The constitutional text, its structure and its history allows for certain things to happen. And it need not have been this way. And so I think that we need to go back to the founding moment. We need to study that a little more carefully and to see how there is a continuity between the colonial times and the post-colonial times. And of course, the argument that there's a continuity between the colonial and the post-colonial times is an argument that's often made. But that the Constitution forms a part of this continuity is, I think, an argument that was initially made in the 1950s by a number of critics. And it still continues to be made, especially when we speak about issues in Kashmir and in those areas. But in the mainstream, I think that has been somewhat muted. And it may need us to perhaps talk about that again. So I want to actually spell out what that continuity entails. But before that, I'll say that national security laws that establish a state of exception, whether it's the UAPA or the NSA, laws that came before the TADA, the POTA, and so on, I think are characterized by 4 features. So even though their provisions are very different and that their provisions can, they do different things. There are a number of different state statutes. I think if you look at it from a bird's eye perspective, you find 4 common features. The first is executive supremacy, which means that it is basically the executive's decision when to trigger, a legal regime that is effectively takes us from the state of normalcy to the state of exception. And then within the statute, you have set up a self-referential regime of accountability, where the executive effectively sits in judgment over complaints against abuse of power by itself. So that's the first feature. The second feature is the denial of remedies. So there is a limit upon the role that independent bodies can play to check abuse and impunity. The classic example, of course, is 43D5 of the UAPA. We all talk about that all the time because it's kind of it is the thing, right? It is the thing right now that is being used to ensure that people stay in prison for a very long time. And I see in the audience there are many counsel who have really fought against that and do it every day. So that's the second aspect of these laws. The third aspect is the jurisdiction of suspicion, a phrase that I borrow from Justice Beg's majority opinion in the habeas corpus case. So normally when you think about criminal law, what criminal law needs is a tight causal link between the crime and the person responsible for it. So you have an offense, so an act, that's the criminal act. You have the person who is accused of committing that act, and you need to establish a very clear causal link between the two to establish guilt, liability, whatever it is. Whereas in national security statutes, often that chain of causation is attenuated to the point of almost non-existence. So whether it is the criminalization of associations or groups, what you have effectively is this preemptive guilt by association almost, that who you associate with, who you're seen in company with, what books or materials that you have that you read, what you have said in the past, that is taken itself as proof of your complicity in what finally is, say, an offense. without the need to really establish that there was a chain of causation that led from the former to the latter. And the fourth is a rhetorical point, and that is the statement. Again, it's originally a Latin statement. I wouldn't read out the Latin. There's no need. But basically, public welfare as supreme law. So the idea that the purpose of these statutes is to provide for public welfare, public safety, and in this amorphous idea of what constitutes the public, the rights of individuals are basically submerged. So we are never told what constitutes the public. We're never told what exactly the threat is to the public that these laws are meant to prevent, other than, again, quite vague statements. But we are told that as long as public safety is involved, the rights of individuals have to take a secondary status. So that is the fourth is the fourth characteristic of this legal regime. And I think that what you see is, if you go into the colonial times, and then the debates around the framing of the Constitution, and then the post-colonial times, you see that these four characteristics are repeated in each of these three eras. And I think, to address, to tackle, to solve the problem, we need to think about how we are going to tackle each of these issues, both as they are found in statutes, in laws, and as they are found in the public discourse and in people's imaginations. So therefore, I'll divide the rest of these remarks into these three phases: the colonial times, the framing of the Constitution, and then, of course, the post-colonial. So in the colonial times, the permanent state of exception that was established by the colonial regime was basically anchored to the sweeping powers enjoyed by the unelected political executive, that is, the Governor General. So the Governor General's office was vested with the powers to issue ordinances having the force of law, that of course still exists under the Constitution, in emergency situations. And the ordinance-making power was what was most frequently used to authorize preventive detention. I think, first of all, I follow what the criminal lawyer and scholar Abhinav Sekhri says when he says that preventive detention is a phrase that's really a misnomer. It kind of almost legitimizes what's being done by using the term preventive detention. A far better term is executive detention or administrative detention, because what you're doing is you're detaining people and depriving them of liberty without trial and judicial determination of guilt. So what you should be calling it calling it what it is, which is executive detention, or at best administrative detention. So I think executive detention is the word that I would like to use. So the ordinance-making power of the unelected Governor General was often utilized to issue orders authorizing executive detention. And even after the incremental growth of representative institutions in India under the 1919 and 1935 Government of India Acts, the Governor General continued to possess overriding powers of legislation, effectively making the partially elected legislative assemblies subservient to the executive. And these powers were at the Governor General's satisfaction and therefore almost unreviewable by the courts. So you have there already executive supremacy and the denial of remedies as being inherent and as part of the legal landscape. While this was most frequently in use during the two world wars, there was also a parallel legislative and executive framework that replicated many of the features of the state of exception, even in peacetime. So it wasn't just a wartime measure. As early as 1818, which is 200 years ago, a little more than that, the Bengal Regulation, that was the first that authorized executive detention for the preservation of tranquility and security from either foreign intervention or, and the phrase was, internal commotion. And I think it's a very telling phrase, internal commotion. Of course, you had in the interwar years the Rowlatt Act, which became the flashpoint for nationalist protests, authorized executive detention for up to 2 years. The Emergency Powers Ordinance of 1932, also a peacetime measure, was used both to ban organizations, and that brings us to the jurisdiction of suspicion, banning associations, and to impose a regime of executive detention. And then, so these statutes are often, they're discussed, they're talked about. But I think actually the statute that really foreshadows a lot of what we are seeing today is the one that I began these remarks with, which is the 1871 Criminal Tribes Act. Because that, I think if you actually look at the UAPA and the Criminal Tribes Act, the closest associations you see, some of them, are actually in those two statutes. Because the Criminal Tribes Act was an act whose defining feature was to establish guilt by association. The Criminal Tribes Act labeled entire tribes as presumptively criminal, established a regime of surveillance, reporting to the police subject to penal consequences, forced relocation to labor camps, and so on. Actual commission of an offense was not required, as long as the official concerned formed a subjective satisfaction that the individual and the groups in question had the potential to commit crimes. Blood or kin relationships with designated criminals was sufficient for the act to apply, representing a complete inversion of the basic criminal law principle of individual responsibility. And the justification for this entire repressive legal regime was the special character of the colony, that Indians were not ready for self-governance, were not ready for self-determination, and therefore you had to have these repressive kinds of provisions. I think that's important because you see that rhetoric replicated during the framing of the Indian Constitution. Now, but before we go there, I think what's really important and interesting is that there was a nationalist response to all of this. And the nationalist response took a constitutional form. So it wasn't just a political critique that was made of the British legal landscape, but a constitutional critique. And so, for example, in various presidential addresses of the Indian National Congress, stalwarts like Motilal Nehru and C.R. Das critiqued this legal regime from the perspective of constitutional rights, of freedoms, and of liberties. Motilal Nehru, for example, in 1919, specifically argued that you cannot, on the basis that there might be some people who are endangering public safety or public peace, impose a law that effectively, presumptively criminalizes the entire population and then requires people to bear the burden of disproving that they are committing an offense. And that a regime in which ultimately the sole determination of that question lies with the executive is effectively a regime that completely gives a go-by to the rule of law and to any kind of constitutionally valid form. And he says that, and this is really interesting because it could be that he's talking about 43D5. His specific words are that no executive in the world, however competent it may be, has any business to usurp the jurisdiction of duly constituted courts or deprive the people of the protection afforded by them. And if you look at 43D5, that's exactly what's happening there, because what it does is it effectively imposes a bar upon courts from granting bail as long as the police version is internally consistent. Right? That's effectively what that section does. It is a statutory bar. And of course, we'll come to some of the ways the courts have I think, very astutely managed to grant bail despite those provisions. But that is effectively what's happening here. And you see how that exact critique was being made 100 years ago against the colonial legal regime. And similarly, C.R. Das, 3 years later, said that the personal liberty of every Indian today depends to a great extent on the exercise by persons in authority of wide, arbitrary, or discretionary powers. Where such powers are allowed, the rule of law is denied. So there's a direct link between the rule of law and the granting of discretionary or arbitrary powers to executive bodies. Now, you can multiply examples of this kind of critique that was made of the British legal regime by nationalist figures, by freedom fighters. There were figures like Satyamurthy in the Government of India Act 1935. In council, he made the critique. And there were many other figures right up to independence. Hansa Mehta during World War II criticized the imposition of an emergency and so on. And so there was this unbroken tradition of freedom fighters, of nationalists, of Congress people arguing that what was illegitimate about the legal landscape of these national security laws that the British imposed was that they were so far away from any kind of effective guarantee of protecting the rights and freedoms of people, that is what made them illegitimate. So that constitutional critique is a really important part of our pre-independence history, and it's really important to understand that, because that is what makes the break at the time of the framing of the Constitution um, very important, and B, also shows us that it needn't have been like this. This need not have been the path that we took. There were other paths that were open to us. And so with that, we can now look at the Constituent Assembly itself. And of course, the starting point is something that is very obvious, and so obvious that it almost needs a counterintuitive kind of an argument to go against it, which is that India is almost unique among the constitutions of the world in that it specifically authorizes an executive detention regime under Article 22. And not only that, the insertion of Article 22 into the Constitution was strongly resisted by multiple members of the Constituent Assembly, precisely on the grounds of individual liberty and state overreach. So you had that entire tradition of constitutional argument that was being made throughout our history against the British. And that argument was continued into the Constituent Assembly against the dominant faction that wanted to maintain those provisions and, in fact, entrench them into the new constitution. Now, defenders of that regime deployed a very broad set of arguments, ranging from the precarious communal situation that existed at that time to an expression of faith that the new government of independent India would not seek to abuse or exploit provisions that the colonial regime had freely invoked to stifle dissent. And ultimately, therefore, executive detention remained in the Constitution. And if you actually look at the debate that went into the framing of that provision, there was a particularly stormy debate over whether what finally became Article 21, which guarantees the right to life and personal liberty, should include a due process clause on the lines of the US Constitution. That is to say, that when the state wants to deprive a person of life or liberty, should they follow due process, as in the US Constitution, or simply procedure established by law, which of course is the text of the Constitution today. Some members argued that due process would allow the court far-reaching powers of interference in government policy, as the US experience had recently shown, including in welfare policy and so on. And on the other hand, if you omitted due process and just had the term procedure established by law, then the court's role would become minimal. Life and personal liberty could be infringed by Parliament simply by enacting a law. And so after a very, very stormy debate on that, finally, the due process clause was dropped. So then at that point, you only had the term procedure established by law, and then you had the executive detention regime. Now, in order to provide a degree of constitutional protection to individuals against arbitrary arrest, in response to the dropping of the due process clause, Ambedkar introduced what then became Article 22, Clause 1 and 2 of the Constitution, which is that the requirement that you need to be produced before a judicial authority within 24 hours of an arrest under Articles 22, Clause 1 and 2, and then Clauses 3 to 7 have exceptions to that if there is an executive detention law that's actually in force. So Articles 22, Clause 1 and 2 were therefore introduced by Ambedkar to bring about some measure of protection after the due process clause was dropped. But what you can see is that is an almost negligible kind of a protection, because A, it just has to do with production before a judicial body within 24 hours, and B, that provision itself is subject to any law that provides for executive detention in the first place. So on the one hand, you dropped the due process clause that would have actually led to possibly a much greater judicial scrutiny of laws that seek to deprive individuals of freedom, and you replace that with a very bare bones procedural safeguard of production before a judicial authority. And that's why in the assembly, it was specifically called a compromise. and criticized on the basis of it being a very, very thin kind of a compromise. And so that ultimately is what the Constitution gave us. And Ambedkar, after a 6-hour-long debate in September 1949, he says in the Constituent Assembly that I'm trying to, in some way, restore the content of due process in its fundamentals without using the words due process. And so that's what we were left with then. And I think that this is something that would then haunt our jurisprudence from the very beginning, because what effectively we got was these widespread powers that the state was given to curtail individual freedoms, rights, and liberties on the altar of a broader public interest, public safety, and public security. And then there was almost a half-hearted afterthought of a protection and the logic was, okay, well, we may have gone a bit too far in doing this. Let's try and pull it back in, a little bit. And if you look at the judgments of the Supreme Court after independence, you see that kind of logic repeating itself time and time again, where the basic legitimacy and the validity of that four-pronged logic I mentioned in the beginning: executive supremacy, denial of remedies, jurisdiction of suspicion, and public welfare. That basic logic is the starting point from which we begin our discussion. And then we ask ourselves, oh, have we gone too far? Do we need to maybe pull it back a bit? Right? That logic then continues throughout our post-independence history. And I think it's really important to challenge that logic by its very root, because we're not going to ultimately secure, in my view, constitutional freedom, constitutional liberty, by conceding in the very beginning that yes, those four prongs are fine in principle, but we just need to tinker at the edges to ensure that they're not abused at some later point. So on that, let's actually see some of the cases that came after the Constitution was drafted. Now, ADM Jabalpur, the habeas corpus cases, as I said in the beginning, taken to be this moment of great shame, this moment in which the abyss was plumbed, and it was this, there was the emergency and the court was under pressure, and bad things happened and all of that. But in a wonderful article called ADM Jabalpur's Antecedents, the scholar Kalyani Ramnath points out that actually there was a whole range of cases before ADM Jabalpur that said the same thing. And when you actually read ADM Jabalpur, what you're struck by is actually the amount of precedent the judges in the majority were able to cite to support their conclusions. So they did not just say that, today for the first time, we uphold the suspension of Article 21. Today for the first time, we uphold the executive supremacy in determining what to do in an emergency. They cited unbroken precedent both from colonial times and the previous 20 years to justify their position. For example, you had the case of Makhan Singh versus State of Punjab in 1964, which involved the emergency proclamation arising out of the war with China, where the Supreme Court, 2 years after, where the Supreme Court basically had held that the proclamation barred the right to move the courts for any remedy, including those under specific statutes such as the CRPC. So and while you may say, okay, the Constitution in its text says that, well, it used to say before the 44th Amendment, after the emergency, it used to say that during an emergency, the rights under Part 3 of the Constitution are suspended. So you can say, okay, the court's hands are tied. If the text specifically says that the rights under Part 3 are suspended, the court cannot then allow for those rights to be enforced. But the Constitution never said that the CRPC is suspended during an emergency. That was a choice that the court made, a choice that followed this whole logic of conceding to the basic legitimacy of the national security statute logic that is the four-pronged set of issues, executive supremacy and so on. And so you see that before ADM Jabalpur, you had this whole range of cases that did this. After ADM Jabalpur, you had actually much the same thing. The scholar Ujjwal Kumar Singh basically says that what has happened is that there is a regime of interlocking legal systems where the state of exception and the state of normalcy have become so enmeshed with each other that what was meant or is supposed to be a temporary and defined situation has been converted into a permanent and undefined one. And I think that one of the stark examples of this is a judgment in A.K. Roy's case, which came actually 3 years after the emergency was over in 1980. And at the time at which we are told that the court had turned over a new leaf, the PILs had come in and things were changing. That's when you had the A.K. Roy's case, where the constitutionality of the NSA was upheld, and the NSA, of course, is one of the still remaining national security laws that are still used on a very regular basis. And in A.K. Roy, the court held that a chain of authority and accountability that solely involved executive action, that is, the commissioner of police as the detaining authority, subject to review powers by the central government, was constitutionally valid. And furthermore, that the trigger for the government exercising its powers of preventive detention was its subjective satisfaction that a person needed to be prevented from acting in any manner prejudicial to the defense of India, the relations of India, and so on. Basically, the subclauses you find in Article 19, Clause 2, was actually fine. And I want to quote what the court said, because I think it's really important, and it speaks to the issue of the fact that the problem is not so much bad judges and a good constitution, but actually it's a continuing perspective that's been taken on these laws. So what the court says is that, and this is in response to an argument that the clauses of the NSA are too vague and therefore allow for much abuse to take place. Court says that there are expressions which inherently comprehend such an infinite variety of situations that definitions, instead of lending them a definite meaning, can only succeed either in robbing them of their intended amplitude. If it is permissible to the legislature to enact laws of preventive detention, a certain amount of minimal latitude has to be conceded to it in order to make those laws effective. That we consider to be a realistic approach to the situation. Though an expression may appear in cold print to be vague and uncertain, it may not be difficult to apply it to life's practical realities. Close quote. As a counsel, I've forgotten who it was, I think a year or so ago, he called the Supreme Court's approach to habeas corpus in Kashmir a hope and trust jurisprudence, that the court would express hope and trust that the government would do the right thing but not do anything itself. And what you see here is what the court said is that actually, yes, when we look at the provisions of the NSA, we see that on paper, they are vague and uncertain, but we express hope and confidence, hope and trust that when it comes to applying them, they will somehow magically become certain and they will become precise when the government applies them to a real life situation. And that takes us back to, again, the fundamental premise, which is that the moment you have a law that ostensibly claims to be in service of national security, national interest, public safety, or so on, those four prongs that I'd mentioned kick in, and the court basically says that yes, we basically concede to the premise of the whole legislation, and whether if there are some problems, if there are some issues, we still think that they'll work themselves out in implementation, but only when there is something that's so blatant or completely cannot pass muster is when the court sometimes steps in. In the NSA case itself, it struck down a couple of provisions that were, I think, too blatant even for it. But otherwise, the presumption is that this is needed and this must remain. And as I said, its roots actually lie in the framing of the Constitution and in the specific provisions and in the way that they came about. So you started with this broad kind of leeway given to the government under Articles 21 and 22, and then tried to pull back its worst abuses by a couple of provisions that would attempt to, in some extreme cases, slightly soften its impact. The other, really, I think, stark example is the case of Kartar Singh versus State of Punjab, which upheld the constitutional validity of TADA, which as it then stood. Now, TADA made a number of departures from basic principles of criminal law, including what is now 43D5 of the UAPA in a slightly different form, which is that that if there is a prima facie case that is made out, then there is a statutory bar upon the grant of bail. And as everyone has pointed out, this is so obvious that it doesn't even need analysis, is that the prima facie case is the state case. At the time of bail, that is the case that the police shows to the court. So you're basically asking the accused to, you're tying one hand behind their back, both hands behind their back. So you're saying that you can't bring your own evidence to disprove the prosecution's case. All you can show is at its highest that the prosecution's case fails on its own terms. There's some inconsistency, or it's so shoddy that it doesn't even make, the prima facie case. And if you can't show that, then effectively you stay in jail until the trial gets over, which is many, many years. And of course, after the Supreme Court judgment in Vatali's case, which again we have talked about so many times, that has been made even harder, because that has made it even harder for the defense to challenge any aspect of the prosecution's case on substantive terms at the stage of bail under the UAPA. So, but you had Kartar Singh that brought it about. You had a constitutional challenge to it in Kartar Singh, and you had the Supreme Court upholding that provision on the basis that because terrorists don't act like normal criminals, therefore you need something special to deal with them. And of course, what that ignores is that no one's a terrorist until they're actually proven so in a court of law. So at the stage of bail, at the stage of anticipatory bail, another issue in Kartar Singh, at the stage of not revealing the grounds of detention to the detainee, at the stage of protected witnesses and what kinds of limits that the statute put on cross-examination, at all those stages, the defense is still representing an accused, not a convicted person. And so therefore, what you're saying is that our assumption actually is that everyone who is an accused under a law like TADA, a national security law of that kind, is actually presumptively guilty. So we are going to judge our legal standards under national security laws. We are going to judge the legal framework on the assumption that the trial is of a guilty person. And we'll ask ourselves that, well, so if you let a guilty person go out and bail a terrorist, then actually they'll obviously use that liberty to threaten witnesses. And sometimes we need to stop guilty terrorists from cross-examination and so on, and all of those restrictions. So again, the underlying premise is not simply a premise that deals with judicial deference or just allowing for a certain kind of abuse, but it's a much deeper thought process that starts with the assumption that under these special laws, we are starting off with the assumption that everyone who comes within the net is guilty, and we need to deal with those people, and we need to therefore change our legal structure to deal with that. And that again goes back to, in my view, the framing of the Constitution and that basic sense that your starting point is no due process, executive detention that can be extended indefinitely. That's your starting point as being constitutional and correct and valid and good. And then we'll see what we can do to maybe soften its effects a little bit. And you have that very clearly coming across in the NSA judgment in A.K. Roy. You have that very clearly coming across in Kartar Singh. You have that coming across in Naga People's Movement for Human Rights, the case that upheld the AFSPA's constitutionality, where entire areas can be declared to be regions effectively off limits to fundamental rights, and so on. So that's why I say that the continuity that we're talking about is not just a colonial and post-colonial continuity, but it's a continuity that's punctuated by the Constitution and in many ways enabled and facilitated by it. The final thing that I want to flag briefly is that now, of course, I mean, this may look like a very pessimistic story, and it may look like that if this has been a 200-year unbroken chain, then it's very hard to displace now. But what we have seen is that even this kind of legal regime does give spaces to courts, to lawyers, to work through the interstices and to still do something that's good for freedom and for liberty. And I'll give two examples and briefly, and I'll end with those two examples and just a closing remark. And the first is the famous Kabir Kala Manch bail judgments of the Bombay High Court in 2013, when the court basically used the Supreme Court's judgment in Arup Buyan and those cases to say that when the UAPA talks about membership of an unlawful association or a terrorist gang, then that the term membership refers only to active membership, and therefore you need to show that the individual involved was themselves party to inciting violence. And you can't just use these kind of broad ideas of conspiracy, of associations to bring them into jail. And using that, Justice Tipse then granted bail to various members of the Kabir Kala Manch. The second, of course, is the much more recent judgment in Asif Iqbal Tana and in Justice Bambani's judgment, where he does something very similar. Because when the statute says that as long as there is a prima facie case, you cannot grant bail, then all you can do is you can say that there is no prima facie case if bail is to be granted. And to do that, you have to show that the facts collected by the police don't reach the legal requirements of the offense in the first place. So even if you take all the facts to be true, the offense is not made out even on those facts. So there's no prima facie case. And so then that requires you to interpret what the offense actually requires. So in Justice Tipse's judgment in the Kabir Kala Manch cases, he says that the offense requires active membership to be established, and therefore you must show that there was incitement to violence. In Justice Bambani's judgment, he says that the word terrorism is itself a very, very specific term, and you can't use it to, and you can't expand its definition to just take into account anything, any kind of public disorder. And so you see that it is still possible for judges to be able to use a restrictive law and still interpret it very correctly and in consonance with all correct methods of interpretation, to nonetheless say that there is still scope for bail to be granted in these kinds of cases. But I think that what's important is to remember that even with these judgments, effectively it is still these judgments are extremely important. But the impact is nonetheless still very marginal, because, well, one thing is you can't always rely upon having judges who will understand the importance of liberty and freedom and work to write judgments that will fulfill that promise. You can't rely on that, and I think we all know that. But secondly, I think as long as that basic logic that, in my view, underpins the Constitution and has continued onwards, as long as that basic logic remains in place, where the starting point is legitimate and we are just concerned with how to pull it back, ultimately we'll always be fighting against the tide, because the entire argument will then be that at what point does abuse become so much abuse that it's no longer tolerable. But that's a very limited kind of argument that's being made, because the issue ultimately is not that these are okay laws that are being abused by unprincipled state functionaries. The argument is that abuse is baked into these laws. So there's no distinction between use and abuse. And I think the challenge is before us is how to articulate that argument in a way that is effective, in the public sphere, in courts, and so on. And I think, and I'll close with this, that perhaps then that means it's actually time to go back to the founding of the Constitution, and to maybe ask some hard questions about whether, if we are going to stick to the story that the constitution is good and judges are bad, if that ultimately is going to just limit how we can identify the problem and maybe resolve it. So I think with that thought, I will close. I see it's just 45 minutes. So on that thought, I'll close and thank you again for inviting me.
We'll take some questions now, which have come in. And, I just thought that the first question which has come in to me is your remark, which you made, I think, twice in the lecture, which is about the 1871 Act under the British, that is the Criminalization of Tribes Act. What were the socio-political circumstances specifically, the questioner asked, that led to the enactment of that statute?
Yeah,
because I think that would be very critical, no?
Yeah, there were many, and I think that I would recommend a book called Dishonored by History by Meena Rajadhaksha that really goes into the full history of the Criminal Tribes Act. So there were many things. So one was that there was this entire British idea of hereditary crime. That there are certain in Europe and in England, you have the gypsies and the Roma, who are believed to just be criminals by nature and by birth. So there was this whole idea of hereditary crime, and because these indigenous groups were groups that effectively, were nomadic. Their concepts of property were different, and they did not, and they were difficult. It was difficult to tax them because they were nomadic, and because they were parts of supply chains that were alternatives to the British political and economic interests. Combination of all these factors brought into place a law like the Criminal Tribes Act. But the basic justification in the public sphere that the British gave was that there are these tribes who are just addicted to crime, and like parents pass on that addiction to the children. So it's basically you're criminal by birth, by association, by blood, by kin, and the only way to stop that is to criminalize the groups as a whole, and then to put them into labor camps and so on. So those are the set of circumstances led to the enactment of the Criminal Tribes Act, and then over time its implementation right up to I think it was in the 1950s it was finally repealed, and they were called denotified tribes.
Thanks, Gautam. There was another question, which is that under national security laws, is it established that burden of proof lies on the accused, like in the citizenship laws in Assam? Or is the presumption of guilt just another example of authoritarian regimes assuming their power?
No, so it's not that the final the burden of proof of innocence is on the accused. It's just that there are a number of steps along the way in which various burdens are placed upon the accused. So, for example, in the NDPS and the drug laws, you have a presumption based on possession, and then the accused has to kind of displace that presumption. In the UAPA, you have the bail provisions where basically the accused effectively has to, I wouldn't say it's a burden of proof issue, but it's more that the cost of keeping the accused in jail is basically very, very low. The things the state has to prove it just has to show that there was a prima facie case, and actually it's not even a burden of proof question, because if the state shows that prima facie case is there, then after Batali you can't even object to that. So it's not even that you have an impossible burden. You're not even allowed to discharge any kind of burden other than the burden of showing the state's case is internally contradictory. So I think that actually as far as I know, and subject to correction, we don't have a statutory regime which actually explicitly says that you are deemed to be guilty until proven innocent at the final stage. But you have these kind of departures from this principle at various stages, like bail, possession, and so on, which lead to many of the issues.
From Karuna John, there are voices against laws such as UAPA. Do you think that public pressure, or will public pressure, if it grows, result in Parliament repealing it? Father Stan's death has put a global spotlight on the law afresh.
I think if you look at history, Tada and Pota both ultimately went in no small part because of sustained public pressure. So I think that public pressure is extremely important, and it's extremely it's indispensable. But what we've also seen is that they go in and they come back in a morphed form, right? So UAPA 2008 is kind of like the intellectual successor, Pada and then Pota. So I think that public pressure is important, but what are the terms under which we are framing the argument? So if we are just going to say that UAPA is being abused, it needs to go because it's being abused. Look at illustration A, B, C, and D of abuse. Well, maybe someday we may be successful and it may go, but you would just then have I don't know, national protection of people from something act, which will just make a few little modifications, and you'll be back with the same problem. So I think ultimately, perhaps we need to also think about how we are framing our objection to the UAPA, and if we can find a way to frame it in a manner that questions the underlying legitimacy to start with of a national security law that sees the need to depart from our core principles, like presumption of innocence, responsibility having to be established to prove a crime, and so on. If we can somehow find a way to frame our objections in those terms, then I don't know. I mean, this is all tentative. Then that may get us to a better place at some point in the future.
Just my addition to that question is that given what you have very, very explicitly and repeatedly explained about Article 22 itself and its inclusion in the Constitution, how should that campaign be then framed? Because given the fact that the Constitution has given legitimacy to some extent or large extent to the fact that we should have some form of national security law, which Parliament can sometimes make a UAPA, sometimes make a TADA, sometimes. That is why where these laws find their legitimacy finally. So how do we need to sharply focus that debate, public debate?
So I think that this is a question that I think requires a lot more. I think maybe even just discussion about how it will be framed. And I don't want to maybe just like give a pat answer. But I think that at least, and this is just my personal view. I think that as long as Article 22 is there in the Constitution, we're not going to get very far. And I know that constitutional amendment is always a dangerous kind of proposition. There are a lot of various issues that are involved in that kind of a movement. So I don't want to prescribe something, but what I will say is that I used to think for the longest time that it's possible to take the text of Article 22 and 21, and despite the history, to read it in a way that is progressive and emancipatory, and ultimately we can work with the text. But I've become less and less sure of that, and at least my personal view now is that as long as the text is there, the logic of it will remain, and so the only real long-term way forward is a constitution without an Article 22.
The question is, there's no name, there's Galaxy J7. Don't you think that inherent abuse in the very use of NSA is hidden within the law? Can we therefore bring in modification or abolish NSA, as there are already sufficient laws there to address the issues addressed by NSA, National Security Act?
I think that the argument again is somewhat can lead to undesirable outcomes. And I remember when sedition was challenged a couple of months ago, I remember one of the petitions said that you don't need sedition because you have the UAPA, right? So I mean that is not an argument. The argument cannot be that because we have other laws that are there to do the same thing, therefore we can get rid of like X or Y law. I think again and I'm sorry if I misunderstood the question and got it all wrong, but I think that ultimately it has to go deeper than saying that we need to get rid of X law because other laws are there that do the same thing. I think the problem is that there are all these laws that do that in different ways, and what they're doing is the issue.
This question is about due process. That what, in your opinion, can be done to ensure due process? Do we need corrective legislation? Or can we accomplish this with just a more humane reading and implementation of existing laws? Okay, I just want to add a bit, maybe a rider to this, because I think there is this concern that sections of the judiciary, and I don't want to use terms like lower and higher because I think that's not appropriate. But for instance, the NIA Act being amended in 2012 and 2014, and you have a very dangerous precedent of special courts coming up, and then the way they are reading into the UAPA, etc., and also the other crimes that are being allocated to NIA. I just want to add that, is there a need for judicial oversight into the functioning of these special courts when it comes to due process?
I mean, I don't think that judicial oversight at this point is a solution, because from what we have seen is that you get extraordinarily good judgments from the trial courts and terrible judgments from the trial courts. You get very good judgments from the high courts and terrible judgments from the high courts. You get excellent Supreme Court judgments and also terrible ones, right? So I mean, I think we've all been through that phase where we go like, okay, the High Court and the Supreme Court don't get it. The trial courts are first and most important line of defense, and then there'll be a trial court judgment like that Ember's judgment of Safura Zarga, right? There'll be a judgment that just is so. I mean, what do you even say? Then we go, okay, like Supreme Court is too far removed, but let's like trust the High Courts. The High Courts cannot get it. And then the Kerala High Court goes into that. The Kerala High Court, the judgment of January this year, right, where they, I think it was someone had a book, and it was again one of those just extraordinary. Where in fact the High Court set aside a special court judgment.
Special court judgment, exactly.
Yeah, saying that the special court judge acted like a constitutional court. So I think that it's just, I think what we have to acknowledge is that that for a number of structural reasons, and that's a whole different, I think, discussion. We don't have uniform, coherent jurisprudence on these issues. And so what you will have is that if you're lucky and your case comes before a judge, and the judge could be in the trial court, could be in the High Court, could be in the Supreme Court. If it comes before a judge who is minded towards protecting the constitutional right, to personal liberty, then you will get a good order that interprets law in a way that advances, in my view, rightly, the cause of liberty. If you get a judge who is unconcerned or executive minded, then you will get the other way around. And as I said, I think the problem is that the constitutional text and the constitutional culture that's been there from the beginning doesn't prescribe either outcome. So both of those are equally defensible internally on the touchstone of the Constitution, because the Constitution specifically provides for Article 22, right? So I think that judicial oversight in itself isn't a solution unless we are simultaneously working towards a constitutional text or a constitutional culture where that oversight will mean something in tangible terms.
Okay, so there are two questions, one on here and one on YouTube as well, both related to something you just touched upon in one reply, but it's a specific question, so I have to ask it. So if the abuse of fundamental rights is built into these laws and it has location in the very structure of the Constitution, would it mean that there is a need for a basic review of that, the Constitution, amendment to the Constitution? I mean, I know you touched upon it, but there are two questions.
I think we need to initiate that conversation. I don't know what form it will take. I don't know what the outcome of that will be, even among ourselves, because, like I said, I think it's a big ask. And as we all know, any kind of call to review the Constitution carries with it the whole
risk.
Risk, freight, baggage. Who will use it for what purpose? So I really don't want to prescribe that kind of a thing. But I also feel that, and I felt this more and more over the last 2 or 3 months, that we simply can't go on in the old way of saying Constitution good, judges bad, because there is clearly something that's missing over there, and we perhaps at least need to start the conversation about structural issues in the Constitution and what we might be able to do about that. But we do need to, I think, start the conversation about what is the Constitution, and is it really what we think it is?
Okay, just for a little clarity, okay, but I'm fully that when you had TADA and POTA both, and those were kind of the legislations that got repealed again because of huge public pressure, but NSA remained, despite the fact that it's been hugely abused, and state preventive detention laws, national security, state security laws remain. Chhattisgarh, Jammu and Kashmir, AFSPA remains. But when POTA and TADA regime was in force, you had in that sense, the argument is that there was a sunset clause to these acts, and you had a judicial review committee. Okay, you had a judicial, I'm not talking about judicial oversight now, but a judicial review committee whenever there was an obvious abuse of the use of that law. While we keep initiating the more fundamental campaign and thoughts that you have raised, should that also be now looked into and read into and demanded about the existing laws till they get repealed?
Oh, right. So no, I mean, I think there are a whole number of short-term things that should be done. I think the first thing is that the Vatali judgment needs to be relooked and reversed. Well, I don't know, that's not really short term because it'll take some effort. It's always hard to ask the Supreme Court to review its own judgment and to reverse it. But I think you see more and more how different high courts and the Supreme Court are really, I think, beginning to understand that look, this is unsustainable. And so to that extent, you have the Supreme Court judgment, I've forgotten its name, but the one that said the right to fair trial continues to operate, and
so
therefore
Kashmir, it arose out of Kashmir,
Right, yeah. So if you basically have if you have somebody in jail for 2-3 years, trial hasn't begun, then
it was a longevity of the
So then the fair trial, right? So 43D5 then will not be a bar. So you have that. You have Justice Bambani's judgment presently in a strange limbo because it is not being stayed, but is not to act as precedent. So I mean, I'll go into a rant. So let me not. You have
we'll all go into a rant. We'll all go into a rant.
Yeah, you have all those judgments that I think are really good examples of judicial craftsmanship. That work with the constraints of the UAPA, and while maintaining a fidelity to the text and to interpretive canons, nonetheless craft a jurisprudence that still allows for those spaces to exist. I think you have all the lawyers who are doing an amazing job, I think, kind of putting forward those interpretations. So I think that all of that obviously needs to continue. And in that way, as I said, the worst abuses of laws like the UAPA can still, be mitigated if you have a jurisprudence develop that despite that is somehow against the grain of its text. So so that's I think a really important thing going forward. I think a lot of legal effort has already gone into that, and it's showing results. So
yeah. And at great cost to human lives. I mean, at great cost to human lives, but the lawyers that band of lawyers is doing an amazing job. There are a few more questions, Gautam, which is great because the discussion just gets more interesting that way. That Karuna John, citizens brave enough to dissent live in fear of such laws. How does more information about the rights of the activist citizen when police or government threaten them with action under UAPA, NSA, etc.? How can this be made more easily available?
Oh, I think that they should just be, and I think they already are, but I think that maybe the dissemination is not as wide because of resource constraints. But there are a lot of primers that exist that really set out what is to be done from the start to the finish of this process. And I think in fact just recently I remember from Bombay, a group of lawyers had made a very detailed note, starting with being detained, right through the various stages. So I think that translated into a number of different languages and made available is important. And of course, it's easier said than done. It's all requires effort and resources. But I think that those primers are there. I've seen a few of them. Maybe it's because they're just on all these lawyers' WhatsApp groups. But yeah, we should I think work to disseminate them more broadly. And I'll ask people that I know who are working on them to what the status now is.
Yeah, thanks so much. Is there anything, another question, is there anything, and this is Rhythm Buaria, is there anything the courts can do to at least hear habeas corpus petitions challenging executive detentions under public safety acts within a shorter period of time? There are no checks on the judiciary. Yeah,
it's really interesting because when the Constitution was being framed, there was a member of the Constituent Assembly, a pretty famous one, either Thakur Das Bhargav or I've forgotten who it was, but they basically wanted a one month maximum period for hearing a fundamental rights challenge and deciding it. And if you look at Latin America, amparo cases against state abuse, 10 days is the maximum time to decide the case in. So I think that is really important, and I don't know if it needs to come into legislation or because I don't see how the Supreme Court can pass a judgment saying that, like to say every habeas corpus case must be heard in 10 days. I think that I don't see that happening. So I think again, maybe it's something that maybe like it's a project of like legislative, addition to statutes or something of that kind. But I think that the time barred requirement to hear habeas corpus cases is important, and as the Latin American example shows, it's not something that's outlandish. I mean, jurisdictions have done that.
This is Nilkunj. Can putting heavy fines on the state in case of acquittal decrease the number of cases, since very few cases ended up in proving the accused guilty in such cases?
Yeah, no, I think that's a great point. And in many jurisdictions, you have this whole concept of a constitutional tort, where violation of constitutional rights is framed in the language of tort, and therefore compensation is required to be paid for a breach of constitutional rights. In India, it was tried a couple of times. I think it was tried specifically in 2014 involving the Akshardham blasts, when the people who were accused and were put in jail for like 14 years. 14 years, and then the case went to the Supreme Court. Unfortunately, it went before I think the then Chief Justice Deepak Mishra, who dismissed the claims for compensation, and I think set a pretty bad precedent in that regard. So I think that there's that bit of struggle there to get to a point where the Supreme Court accepts kind of like as a principle compensation across the board. So we do have it in some cases. And we do have like a few cases that talk about it, but I think it doesn't get established as a constitutional doctrine, and isn't anchored in something like a constitutional tort. So I think the next step is to get to that point, but I think it's a very, very important step, and specifically if you individualize the obligation to pay compensation and not have this vacuous thing that the state will pay compensation, I think that would be a more effective deterrent if it was actually crafted as a legal remedy.
All these legislations, whether it is POTA, TADA, NSA, UAP, AFSFA, they all have clauses where they say that if the prosecuting official, stroke administrator, stroke whoever, is acting in good faith, then no action can be taken against them. So they have built into these statutes. I mean, of course, it doesn't have to apply to compensation, but they built into these statutes and protected officers right from the investigating officer upwards, who might maliciously continue prosecuting a person or a group of persons. And the protection is built again into the statute.
Yeah, so the problem there exactly is that you have to prove that the officer wasn't acting in good faith, which is a very hard burden to discharge.
That's right. That's right.
You will almost never have a smoking gun of that kind that will show it. I mean, what you're actually looking at is like a leaked conversation or something that shows that it's actually a person was going after somebody. Because otherwise, the officer can always just say that, look, honest mistake. I mean, we thought the evidence was there and it wasn't, but we thought it was, and what else were we to do other than prosecute? And in fact, it just shows the system is working because we prosecuted and the court acquitted them. So I think you have that. It's really hard to get over that hurdle. Of course, the answer then is a more broad-based compensation regime that
absolutely.
But then that leads to the whole problem. It's not a deterrent anymore, because then effectively it is taxpayers' money going back, right? So that isn't really a deterrent. So I think you're caught between the problems of establishing individual complicity in malicious prosecution and non-deterrence of state compensation, and that's kind of, I think, the dilemma that's there.
There's a comment from Anjana Prakash, ma'am, who said that I would think that the only remedy is that the courts ensure that procedure established by law, quote unquote, meets the basic tenets of criminal law like presumption of innocence, or the structure of courts is not disturbed. This because we know the pretext of procedure established by law is really the source of abuse.
Yeah, no, I think that's completely right, in the sense that and this reminds me of Justice Khanna's line in his dissent in habeas corpus, is the history of personal liberty is the history of sticking to procedure, right? I don't want to also sacralize procedure too much. There is a risk in that, but I think that right now, what's interesting is, as a historical point, after the PIL era 1980s onwards, you had this whole thing the Supreme Court kept saying, well, procedure can't stand in the way of justice, so we need to do complete justice. Therefore, X or Y procedure is standing in our way. We will kind of ignore that. But the impact of that goes beyond just PIL, right? It goes to a general disavowal of procedure. And when that bleeds into criminal law, where justice then is kind of community justice, protecting the public, catching the guilty, it becomes so easy then to say that in the interests of justice, things like default bail, right? Things like those time limits on filing of charge sheets and so on, which you would hope that the court would interpret very strictly against the state. It becomes easier then for the court to say, well, in the interests of justice, we will not let these procedural hurdles stand in the way of effectively prosecuting the case. So I think that a renewed focus on the importance of procedure, not just as something that is a hurdle for the state, but as something that really maintains the equality of arms.
Checks and balances. I mean, the basic checks and balances, right?
Checks and balances, but a little more than that. In that, the inequality between the individual and the state, when the individual is arraigned in the dock as an accused in a crime, is so great that there has to be something that mitigates that inequality, and procedure is something that does that. So I think that to maybe really stress the importance of that would be that's I think that's necessary.
Few more comments, Gautam. A lot of comments coming in from YouTube as well. This is Sureka Talari saying that it cannot be a fixed definition of national security. It is time sensitive. It is circumstance sensitive. It involves all mega and micro factors that impact citizens in given time. Political terrorism or dissent is a very narrow approach to define national security. National security needs to be defined by the Supreme Court very clearly. Just now, it is being interpreted as per the government's convenience. As long as it goes that way, the law will always be abused.
Yeah, I mean, I think that you're right in that it's obviously being interpreted by the state as it wants to, and the court is deferring to that definition. But I don't know if the court defining it is a solution, because I think that the court defining it, you're still going to have the state enforcing it or implementing it. And I think you can see so in Ramanovar Lohiya's case, right? The court drew this distinction between law and order, public order, and
the concentric circles.
Yeah, the concentric circles, right? So it drew that distinction. Now, and it's a distinction that I think I love to cite. I think we lawyers really love it. Like we keep making that point in especially in court, and it has helped sometimes. But I don't know if it really helped like in kind of a long-term way against the encroachment that these kinds of statutes do, because these kinds of statutes are premised on the assumption that they are responding to the gravest of possible threats. So you're no longer in that situation where you can say, oh, actually, your competence or like your constitutionality of it depends on this law being a public order law, but actually it's only a law and order law. Therefore, it has to be struck down. I think that those kinds of arguments, whereas are useful at various places, when you're dealing with the kind of things happening under UAPA, and the NSA, and I mean here constitutionality. I don't mean So if Justice Bambani's judgment is a great example of actually like defining terrorism in order to ensure that you can't just grab people under UAPA and put them in jail. So
as narrowly as possible. Define
exactly.
it as narrow.
As consistent with its ordinary meaning, of course. So I think there's a place for that in individual cases. But I think that a general purpose definition of national security by the Supreme Court, I'm not sure of how much it will help, at least like with that.
Why can't we repeal such laws using Article 21? I mean, I wish we had answers to that.
I mean, unfortunately, they've all been upheld on Article 21 grounds. So I think that ship has sailed.
Yeah. This is an interesting question from Pradyuman saying, do you think it will be dangerous to enforce the natural rights of life and liberty that exist outside the text of the Constitution in cases that attract national security laws? This is in the context of the Puttaswamy judgment that expressly overruled ADM Jabalpur.
Yeah, I think that I would tend to agree. I think that looking at natural rights outside any kind of constitutional, structural, historical argument is a dangerous proposition, and I think that we should be alert to its dangers. Rights are always contextual. They have a history to them, a specific political, social history, and ultimately they have to be anchored in something. So I agree that even though this sound intuitively plausible, and the argument often is that if like tomorrow the constitution is gone, then natural rights are going to still be there and help us. To which I'd say, if the constitution is gone, then I think we'll have bigger problems to worry about than being able to establish like natural law in court. So I think but I think they can be used to a lot of harm. And in fact, if you look at some of the arguments in that are often made in the US, and in certain parts of Europe, where they actually invoke natural rights to advance a really conservative, narrow understanding of rights that excludes a whole range of people, including women. I think that we need to be on our guard against that kind of thinking.
We are now sort of, I think, at the end of our questions. I just wondered, Gautam, that given the questions, whether you would like to just make some concluding remarks in terms of where we could go now, before I then just make 1 or 2 points and hand over to the chair. Yeah.
No, I think that the questions were all great. It was a pleasure responding to them, and some of them, of course, I think are impossible to respond to because the answers are beyond any one person. So I think that I'd say maybe 3 or 4 things. I think first of all, I'd say that all the lawyers who are doing these cases are doing a wonderful job, and when you follow the proceedings in court, I think that within the constraints of what these laws can enable them to do, like they're doing the utmost. So I think that is great to see, and that will of course continue. So I think that'll continue on its own trajectory. I think beyond that, there are maybe it's worth thinking about short-term, medium-term, and long-term goals here. So short-term, of course, is to push and advocate for a progressive reading of these statutes on the lines of what Justice Bambani did in his judgment, on the lines of Justice Tipsay's judgment, and to try and demonstrate how this interpretation is consistent with constitutional safeguards. That's the short-term approach, short-term solution. Medium-term, of course, is I think that there are all these precedences, Vatali and maybe even Kartar Singh and those kinds of cases, to see how there can be a concerted argument made to rethink some of these provisions these judgments that have, I think, entrenched the executive-centric view of these laws and those 4 things that I mentioned, the 4-pronged approach. So to see if we can kind of make a case for why that's wrong and inconsistent again with constitutional safeguards. I think the long-term solution, as I said, is maybe to initiate a conversation on the Constitution, the Constitution's design and structures, and how they do or do not perhaps enable this to happen, and what a resolution might look like. And I think all these 3 can take place, side by side. Yeah.
There was one more question which has just cropped up that it's about Bhima Koregaon, so I can't resist asking it because we do have some time. Yeah. Which is, even when the accused are taking it upon themselves to establish their innocence, for example, the way the Bhima Koregaon accused have presented the Arsenal report, which is a clear example of, not just tampering with evidence, but actually malware kind of manipulating evidence to the nth degree, is the failure of the courts to even take cognizance of the report another case of a miscarriage of justice?
I think the writ petition has been filed on that.
It's been filed, but I think there's been a delay, and it's not been heard. It's before the High Court. It's pending in Rona Wilson and Shoma Sen's case.
Yeah. So I think the delay, of course, is something we've seen is a recurring problem. And I can just say I hope that that's taken into cognizance. And
I just want to add that, because I know a little bit about it, that I don't think it's just the courts. I think the state's intransigence, it's apart from NIA and the union government, even the state of Maharashtra, in even trying to test the Arsenal report vis-a-vis their own independent, some local experts, using what the Arsenal report has come out. It's like you don't even want to look there, which I think is really irrational. That if a set of evidence has been put before you and it's from a US, it's a highly specialized experts from the United States, you need to retest that, right? You need to find out whether it holds true. So I think at least it behoves on the state government or state agencies, the central agencies, to refer the findings of that to independent experts who are based in India or wherever, whomever they may trust. But to completely deny that you're going to even look at it, I think is really part of the problem. It's which is hopefully will be addressed by the courts as and when it's heard. Yeah. So thanks, Gautam. It has been really a privilege and a pleasure, and as always, given us a lot to think about. Though it's not an easy way out, as you say, it's a very tricky road in a way, but it's not something one can turn away from. You made the time. You took a lot of energy, addressed all the questions. Thanks very, very much for that. For all of us, for all of you who've been listening and who've been with us actually and remotely, this is the third of the 4 series that we've had in the lead up to September 5th, as you know. We've had Professor Nageshwar Rao in the first panel, whose work on the Constitution, taking it in Kannada to the people of Karnataka, has been quite a movement in itself. We are very grateful to him. We also had a very, very interesting panel discussion last Sunday on the whole issue of the challenge to the media and surveillance and the deep state with the whole Pegasus exposure, and the fact that not mainstream, but we like to use the word big media as trying to drown out whatever the real media is trying to say, these alternate channels, alternate voices. And we had Probir Purkayasta from NewsClick, and we had Siddharth Vardarajan from The Wire, and myself. It was a very interesting panel discussion. And now we have today. So third very, very important lead up to September 5th. And next Sunday, just to let all of you know, is also going to be quite special. We urge you to join us. And what we thought we would do, because it's September 5th, the day that Gauri was killed, is that we get, and she was really, Gauri really related to young leaders of our time, and who were showing us the way with so much courage. Gautam is certainly one of them. But I remember the way she related to Kanhaiya, to Jignesh Mevani, Umar Khalid, Shaila Rashid, when JNU was being attacked in a brutal fashion. So we thought it was only fitting that next Sunday we have with us Asif Iqbal Tana, Devangana Kalita, and Natasha Narwal in a kind of a live engagement and conversation about Gauri and about their own incarceration, because they become iconic role models for all of us. And that will then lead on to one more lecture by somebody whom we hold very, very dear in the human rights fraternity, senior counsel and a dear friend, Mihir Desai from Mumbai, who has been amazingly among the band of lawyers who's been looking into many of these very, very difficult cases, particularly the Bhima Koregaon case. He's also vice president of the People's Union for Civil Liberties, PUCL, and of course a human rights lawyer and activist in his own right. So that lecture will be next Sunday after a kind of engaged evening with our 3 young student leaders. So we urge you to join again. But before I hand over to Professor V. Sridhar for his concluding chairperson's remark, I want to, from all of us, thank Gautam Bhatia very, very much again for opening up a lot of ideas, questions, and challenges for us. Thank you, Gautam.
Thank you. Thank you so much.
Thank you, Tista, for moderating this session, wonderfully bringing all the questions. As you said, Gautam Bhatia's lecture today was in a way a prelude to what we're going to have next week, which will be focusing exclusively on the UAPA. Gautam Bhatia has raised a number of pertinent questions, looking at the whole issue of constitution from various angles, from the colonial to the post-colonial times, and how certain fault lines have stayed in the constitution. So it's not a question of some judges being good, some judges are being bad, or taking subjective positions, but we have to look into the fundamental fault lines within the constitution. So it's a very, very important point that needs a lot of debate, of course, and it's also, we have to tread very carefully now, particularly with the present dispensation, which is also talking about changing the constitution. So the whole burden of demanding a revision of the constitution to protect human rights, to uphold the basic tenets of constitution, has to tread very, 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 it has to be tread with a lot of caution. So I think there was this element in his talk today, that while we need that kind of revision, we should also think a lot. Uh, it should not lead us to more chaotic situation. But what actually matters to us today is that, as he pointed out, there are those four issues that he talked about, or that can describe the special act, the National Security Acts. So one is that executive supremacy, the demise of the denial of remedies, the jurisdiction of suspicion. It's a very nice phrase that tries to encompass how today mere suspicion itself is enough uh, to make somebody uh, lose his rights or her rights, and then can be branded a criminal for life. And then at the end is the public welfare itself. The public welfare is supreme. So this whole idea of who constitutes this public, and how is that this public is above people, because people also as individuals matter, collectively they can become public, but once we hang on to very amorphous concepts like the nation and the public without taking the people involved there, it can take us to very dangerous spots, as it has uh, been so far. So we can, so the preventive detection itself, in a way, as he said, is also a way of um, criminalizing people without proving anything. So that's one of the most uh, dangerous thing, one of the things that we need to be concerned about. And in a way, we can say that when it comes to the National Security Act and this UAPA and TADA and many other special laws, which have been there in one form or the other since independence, and more so since emergency, we see that they have only tightened the screw. And in a way, some of the basic things like human rights, the right to life, right to free justice, etc., are becoming a kind of footnote in our life today. So the Constitution seems to be very silent about that, as if it has to be evoked by only good people, but by itself it can. It's become very pliable. A constitution that becomes extremely pliable can be a problem, and we have seen, we have been a witness to that kind of stuff now. So, um, where is the way out? Where is the way out, as he hinted at in his speech, is to begin a debate about why constitution needs to be rethought. That debate needs to be, we should begin that debate is extremely relevant and important. Of course, taking all the other precaution, and certainly, while constitutional remedies, constitutional reframing are all important matters, perhaps ultimately this debate will also should be strengthened a lot by people's movement, because these debates cannot happen in isolation in academic circles. It has to emerge from people's movements and people's concerns. So let's hope that we'll never lose hope on that. So let's certainly hope that the people's movement will emerge that will take up this issue of the revision of the constitution so as to strengthen the constitution. So we need to reread the constitution to save the constitution, because saving constitution should also mean saving the dignity and life of the people of this country. So with this, I think I will conclude my remarks, and I certainly look forward to the session next week. which will in many, many ways continue the debate that we have had today. And on behalf of Gauri Memorial Trust, I would like to thank Gautam Bhatia for having spent some of his very precious time with us, and also, more importantly, for sharing his thoughts, which are very, very relevant today. And there's a lot of food for thought. So thank you very much. And thank you very much, Tista, for having brought these people together, for having conceptualized this kind of series and then conducting them and this series so well. And all the participants and who logged in today and were also part of the live streaming. I'm sure that this debate will be there in the YouTube for people who missed it today. So we hope to see all of you next week for a lively discussion, and above all to listen to those youngsters who are the victims of this UAPA but have managed to come out, because their experiences matter a lot to us. So good night. So I look forward to meeting all of you again next week on 5th September. Thank you.
Thank you, team, CJP. Thank you, everybody. Thanks, Deepu, so much for everything.